member of parliament, which is an honorable position, I no longer hold that position. So another person has taken over that position. So it's honorable member of parliament, Mr. Makebi Zulu. Now that I'm not a member of parliament, I remain Mr. Makebi Zulu.
No,
I know others will insist on being referred to as honorable, but I'd rather drop it.
No, you remain honorable to many of us. You served as member of parliament for Malambo. In the last 5 years, you were our minister in the previous government. So the honor is due. However, I've been searching and looking for you to come and feature on the podcast. So thank you finally that you are here.
Thanks for having me.
Today we are discussing the state of human rights in Zambia. Recently, the United Nations Human Rights Commission have a special rapporteur who issued a very scathing report on the state of human rights in Zambia. The independent experts stated that there were multiple concerns of arbitrary arrests, unlawful and prolonged detentions, and then, unlawful assembly, where members of the opposition were being charged with things like unlawful assembly, espionage, hate speech, and a new charge of seditious practice. And nearly all opposition leaders have faced these charges. And they stated that other persons, such as human rights defenders like Brebna Changala and others, have also faced this similar harassment. There's been wanton and restrictions on gatherings, on meetings, on peaceful protest, on rallies, and there are restrictions on political players, I think, like the former president. But before we go into the meat of this, Zambians have heard you comment about these matters. But they don't know who Makebi Zulu is. So let's start from there. Who is Makebi Zulu?
It's very difficult to speak of oneself, but I'm a second born in a family of 10.
Wow, that's a big family.
It is a big family, a big happy family, I must say.
Yeah.
And born from one Alex Benson Zulu and Joyce Piri, who are my parents.
Are they alive?
Yes, they are. They're very much alive. They're very much alive. And
blessed are you.
I thank God that they're still alive. I thank God that they're still alive, and it gives all of us, the 10 of us, an opportunity to honor them whilst they're still alive. It's a tendency for most people to honor their parents after they're long gone.
Yeah.
But God has given us an opportunity to honor them whilst they're still alive. I was born way back in 1981.
That's recent.
Yes.
For the achievements you've achieved here in 1981 years.
Well, 1981, I was born on Christmas Day.
Wow, you're a Christmas baby.
Of course.
You should be Noel, you should be not Makebi. Unless Makebi in Chicheba or Nyanja is Noel.
I actually was told that I received free nappies from KK for having been born on Christmas Day. So the first president gave me napkins.
Yeah. The tours at the heads of state
exactly.
do. Were you born in Lusaka at the West Teaching Hospital?
Yes, I was born in Lusaka. Yes.
Ah, yeah. Wow.
So I got to get a hamper from the president then. Yes, and for my primary school, let me just fast forward. Of course, grew up in Kanda Square. Primary school, I was at Lusaka Boys from grade 1 to grade 7. Then thereafter, I went to Munali from grade 8 to 12. Then thereafter, went to the University of Zambia. That was in the year 2001. Yes, I pursued my LLB there. I graduated with a degree in law. And thereafter, I worked for the government.
Okay.
Yes, so...
Under which chamber did you work? Legal aid, did you work at DPP chambers or Attorney General's chambers?
At that particular time, we were rotating. So I've worked in the Attorney General's chambers.
Oh, they would rotate you on all the chambers?
Yes, I worked in the Civil Litigation Department. I worked in the DPP's chambers. And the last place I worked from was Legal Aid Board. Then left Legal Aid and joined Fedger and Company. After that, formed Makebi Zulu Advocates.
Why did you choose to pursue law? What motivated you?
It was the time I was in grade 7, and the story is quite interesting.
Yes.
Prior to that, my father is a pastor.
Mm-hmm.
I always told myself I was going to be a pastor because, you know, every child sees their fathers as their
the
hero.
Biggest role model.
Exactly.
Yes.
So I said I was going to be a pastor. And at that time, you know Mr. Wright Musoma, the president for ZRP.
Yes.
Mr. Wright Musoma, we used to go to the same church. So I was in grade 7, and he used to weld at Long Acres. Right where Barclays was, or
yes.
now ABSA. There's a play park there.
Yes.
Yes, he used to weld right from there. He was doing gas welding from there with Mr. Robinson Kumba, John Kaptula. So one time I was coming from school, Lusaka boys were just there, and I was headed home. I would always visit them from time to time. So we sat there and we were discussing. He says, "What do you want to be?" I said, "I want to be a pastor."
Yes.
And he says, "Yes, of course you will be a pastor, but what other thing do you want to be besides being a pastor?"
Yes.
Now I thought to myself, I don't like manual work. I like to read. I like to work with my mind. And I said I was going to be a lawyer. And from that time,
as a second option.
Well, not necessarily as a second option, but something that I thought I was going to pursue. Because if you're going to preach, it's an issue of speaking. So the closest thing that requires you to speak was going to be law for me. And I said, I was going to my mind. I never had option 2, option 3.
So from grade 7?
From grade 7,
you focused on being a lawyer?
I knew very well that I was going to be a lawyer. Such that the time I was in school, from grade 8 onwards, I would always be in the debate club and scripture union. Those are the 2 clubs that I was consistent with all the way until university. I was consistent with those. Sometime in grade 12, after I left Munali, I had a short stint with civic education. Then there was Mrs. Lopa, the wife to General Lopa.
Yes.
Yeah, she took me in, and that was from the time we were debating. I was one of the best speakers when we were doing our mock parliament debates.
Okay.
Then I was in grade 12. I must have been in grade 12. And at that particular time, I was representing Zambezi West, in the Zambezi West constituency.
In the chamber.
Yes, in the chamber. And I
came what was the topic under discussion?
Well, we were members of parliament, mock members of parliament, as it were. It was a mock parliament proceedings. And that was my first stint to sit in parliament and be able to debate and be part of the proceedings, the mock proceedings, as it were. So thereafter, I joined civic education. The moment we joined civic education, Mrs. Lopa included my name on the list of those to be trained as paralegals. Yeah. So went to UNZA. That was the time I was waiting for my grade 12 results to come out. Yes, went to UNZA, did the paralegal training, and during that time we were taught by Mr. Sangwa as a paralegal. He taught me twice as a paralegal. And thereafter, I enrolled into the university sometime in 2001. Yes, September in particular. I got to the university, and yes, that's my story.
That was your journey into law.
Exactly. Yeah. So from there, we left off at the part where we formed Makebi Zulu Advocates. Then sometime in 2016...
Why did you step out of government to form your own legal practice? To go into private practice and then later form legal practice?
I think I've always been ambitious, and the idea of studying law was also the fact that I wanted to do something where I could stand on my own. Okay. I didn't want to be employed for a long time, to work for someone for a very long time. I wanted to do something that enabled me to work on my own. Okay. Yes. I remember having a conversation with my father where he said, "Why don't you become an economist?" I said, "I don't want to be an economist." And he said, "But it will take long for you to get established as a lawyer." I said, "I'm willing to stick it out. Wow. But eventually I will get established." Studying economics, I don't think that's my thing. Maybe it's because I didn't like the mathematical part of things. The only mathematics I needed was how much is my change.
Yes.
That's the most important part
less
of the
mathematics.
Yes, there's less mathematics. Yes, so I got
law.
I got into private practice, and the time I got to Fedger and Company, I was with a colleague of mine, Mr. Bokani Soko. We worked together for some time. He went into business. When he went into business, I formed Makebi Zulu Advocates. Yes. We were ambitious like that. Even the time we were at Legal Aid, myself, himself, and Mr. Lukangaba,
Yes.
We said we need to step out. We need to step out there and just do our thing out there.
No, the Lord has been gracious to the three of you. Lukangaba became, special assistant to the president for legal affairs. Mr. Soko is a renowned Lusaka businessman. You even became a member of parliament and a minister.
Certainly.
Did you feel that you had abandoned the law practice when you ventured into politics? What persuaded you to go in? Because your law practice was, in fact, thriving. You had clients such as the former President Rupia Band and others, and you had some of these big cases in the country.
My journey into politics was quite interesting. In 2001, no, not 2001, 2011, just after the Patriotic Front won, there were quite a number of cases that arose during that particular period of time. There were a lot of election petitions. So we took up quite a number of election petitions and argued them. And then there were issues of arrests of politicians, those that were in the
previous government.
In the previous government, there were those arrests. I got to represent quite a number of them, and one of the notable ones was Nevas Mumba. Just when he returned from Canada, there was RB himself. Quite a number of people that I got to represent, and during those cases, during the interactions with the politicians, I think the interests kind of emerged.
Spiked.
Yes, and mostly it was the conversations I would have with RB, who would drive from Lusaka to Chipata and have conversations, and he would tell me stories of how he got into politics, his experience in politics, his experience as a diplomat in the political sphere. It was quite interesting. It was pretty much interesting, such that in February of 2016, it started as a joke. I said, okay, I think I need to get into politics. So we were having a chat, and the chat with my cousin, Mr. Elton Posha.
Oh, okay.
Yes, Elton Posha is my cousin on my dad's side and my uncle on my mom's side.
Posha the minister?
Posha the minister, yes.
Wow. So you are cousins?
Yeah, we're cousins, and on the other side, he's my uncle.
Okay.
Yes, so we're having a discussion. I told him I'm going to stand in Mnali constituency.
He had been a mayor, he had been a councillor. He had been
eyeing Mnali constituency. So he goes and he comes to me and says, no, you can't stand in Mnali constituency. I want to stand in Mnali constituency. I said, but I want to stand in Mnali constituency
too.
So he goes somewhere and complains to say, no, because he wanted to stand on the Patriotic Front ticket. He says, it's likely that he may be adopted because he's close to RB, and RB is a person of influence. So why I'm going to have a discussion with him? So he comes to have a discussion with me and says, why don't you go to the village and you stand there? I'm like, okay, I could, if I had to. Then I remembered that one of the clients that I had was Mr. Maxwell Mwale.
Oh, Maxwell Mwale, the former MP for Malambo, and former minister of Mines.
Yes, former minister of Mines. He's a great man. We worked very well together. So I called him up and said, I'm interested in standing in Malambo. And he said, okay, I can help you.
Wow.
I can help you. So we forged that relationship, and we worked flat out. We went into the constituency. We went to almost every corner of the constituency Now you're talking of February of 2016. The election is in August. So the time in between was
barely 7 months.
Yes, barely 6 months in between, before dissolution of Parliament and all. So in this period, we had to make sure that I am known everywhere.
Yeah.
And was a viable candidate. And
for whoever was looking for a candidate in Malambo.
Whoever was looking for a candidate in Malambo. And I got quite a lot of support from the former president, RB. And he introduced me to quite some notable people from Malambo who were with him in UNIP, but still had influence in Malambo. Yes. And that's where I come from. My mother comes from that side. My father comes from that side. So it was an interesting journey. But thanks to Honorable Maxwell Mwamba for the great job that he did. He was my campaign manager. Together with Mr. There's a gentleman, Mr. Kamuna, who came and joined in as well. In the campaign. Who also tried a stint to... What
were some of the revelations in the... revelations to you in politics?
The revelations in terms of...
you grew up in Lusaka, you've been a professional lawyer.
Exactly.
And then you are in the deep end of this politics, where you have to be at grassroots and in the rural areas.
But the thing is that I used to go to the village from time to time.
Okay.
Exactly. Okay. And... there was very little known of me because I would only visit my relatives there in the village. And yeah, the person that I was going to stand against is a person that was almost there all the time. And to move the tide to a person that is known and came out second in the previous election, to me, a novice, never been in politics, getting in for the first time, and having to do all the hard work, it was an amazing experience. I would say it was by God's grace. I just had to be there, and God did everything. Of course, through my campaign managers, I had to borrow credibility from
Maxwell
Mwamba, a very good man. Yes, it was.
And did you learn to speak local language?
I could speak. I could speak the local language.
Not standing with a translator.
Not standing with a translator. I could speak. I could speak the language because I was very fond of my grandmother. And grandfather. And when I was with them, they would always speak to me in Kunda. So Kunda was not strange to me. And every time I went to the village with my relatives, we spoke Kunda.
Does Kunda sound like Ngoni, like Chewa, like Bemba? What is it?
It sounds like Nsenga.
Okay,
yes,
like Nsenga.
It sounds like Nsenga, but some intonations of some words are pretty much different.
Okay.
The original Kunda itself, the language that is spoken by the Kunda people, is supposed to be Betwe, which sounds more like Visa.
Okay.
So Kunda is an amalgamation of Visa,
and
Betwe, and Nsenga. So it's somewhere in between. Yes.
Okay.
It's a very interesting language.
Oh, wonderful, wonderful.
So that was my stint in politics.
And you became a member of parliament. I think you were very instrumental in issues of law. Quickly you associated yourself with the issues, for example, of Bill 10. And then you were running an administration as minister, provincial minister for the province. What were your experiences there? What did you bring to the office, for example? Let's start with the office of the minister. Because now you're looking at Eastern Province.
Exactly.
You know the perennial problems, agriculture issues, infrastructure issues, lack of feeder roads, crossing points, animal, people conflict.
Human-animal conflict.
Yes.
It was an interesting posting. I've never been a backbencher.
Yeah.
Even before we could go to Parliament, I was privileged to have been appointed provincial minister, and thanks to President Edgar Chagwalungu for having had the confidence to appoint me as provincial minister. I could not have asked for anything better, because as provincial minister, you were in charge of the province. It's as good as being a governor or running a small country, as it were, because all the ministries were under my supervision. in Eastern Province. So issues to do with infrastructure, issues to do with agriculture, issues to do with education, all those were under my office for the province. So in that particular period, it was an issue of how best can we leverage on our potential as Eastern Province to be able to attract investment into the province, to be able to bring about infrastructure development, as it were. And of course, the niggling issues were issues to do with roads, issues to do with schools, hospitals, accommodation, and
for civil servants.
Yes, for civil servants. It was an interesting journey. We got to do quite a number of health posts. We got to do quite a number of hospitals. I saw the president recently was commissioning a hospital in my
in Mambwe,
in my constituency.
Did you start?
Of course,
that mini hospital, because
yes,
we saw the president take pride that they built a new hospital in Mambwe.
By the way, it's not a mini hospital. What we got, a mini hospital, we took it to Msoro.
Okay.
Then that particular hospital
is a proper district hospital.
It's a proper district hospital. As a matter of fact, it's better than most district hospitals because as at now, Chipata General Hospital is referring certain patients to Mambwe, to a district hospital.
Why?
Well, because it has all the amenities that ought to be there.
The hospital equipment?
It has all the equipment that needs to be in a hospital.
Okay.
MRIs, scans, CT scans, X-rays, all those are there. And that package, I had to go to Minister of Health. I had
what is provided
so that is provided for. And we were asked, okay, give us land. We had to go to Chief Munkanya. Chief Munkanya allocated land. We got surveyors, they surveyed the place, got the land. And I remember during the campaigns when, at that time, the hospital had already started being built, and we said, okay, listen, we are building this hospital. Mambwe district never had a district hospital. We're relying on Kamoto, which was a mission hospital, and of course, we were equipping it, we were supporting it, but we needed to have a district hospital, as it were. So that was the biggest achievement and success that we scored in Mambwe. The very fact that we had quite a number of mini hospitals, we had quite a number of health posts, and now we built that state-of-the-art hospital. It was a great thing that we did. And I'm glad President Hakainde Hichilema acknowledged that it was a masterpiece. He only failed to mention that
Makebi Zulu that he started under the Patriotic Front.
That the Patriotic Front did a good job to set this up. He failed to acknowledge that, but it's still okay. The people already know that we did that.
And it's to the benefit of the people.
Exactly.
Your experience in Parliament?
My experience in Parliament was quite interesting. See, getting into Parliament, every time I watched Parliament TV, I would get upset. I would get upset.
Why?
Because sometimes I thought the debates were quite shallow, and I thought people were just there to say, and, question, and all. But I was looking forward to being able to discuss and debate national issues and debate them seriously and not be perceived as a joker in the process, because I think it's serious business. And whatever decisions are made there
have an impact
are decisions that have an impact on the country. And the good thing is that we had a very serious speaker of the National Assembly, Judge Matibini then.
Judge Patrick Matibini.
He did a great job. It hurts right now to see what it has become of the presiding officers then. When the previous presiding officers were great serious people, very serious, that had the interests of the nation at heart, not the interests of a political party at heart. I wish that could change. And if it could change now, if it could change as soon as yesterday, it would even be better, because we have lost that house. The meaning that it had to the nation is seemingly being eroded at a faster rate, and it will be difficult to regain it unless we do something about it.
No. The happenings in the current National Assembly is actually an issue being cited by human rights reports that freedom of expression has been eroded, intimidation, harassment of the opposition. They've been cited in human rights reports. And
that should be an embarrassing thing.
Yeah.
There's no way a respectable house such as the National Assembly could be cited in a report that relates to violation of human rights.
Yeah.
That is supposed to be a place where we strengthen the protection of human rights. That is the intention of the National Assembly, not as a tool to violate the rights of people. It shouldn't be that way. So the individuals that are abusing that should obviously...
No, it's actually attributable, as we come to speak later, it's attributable to the president, because the president is fostering a dictatorship through his appointments, through his operations, and through his regular interferences in independent institutions of democracy, independent institutions of our country. It is emanating from there.
I think it's because he has a misconception of what it is to be president. He thinks being a president is like being in a monarchy.
Like being a king.
Like being a king, where you rule by decree and everything is under you. He doesn't really understand the concept of separation of powers. And if only he understood the concept of separation of powers, he would know how far his power goes and how far it doesn't. But even then, the people that are appointed, if they had sufficient integrity to know and say, oh, President, you can only go so far. This is not your domain, would even be better. So it's also an issue of having persons of integrity who understand their role in the positions that they are put in. The very fact that the appointment may emanate or may involve the president does not necessarily mean that your loyalty has to be to the president.
It has to be to the
Constitution, the one that sets
and
up
even to the presidency,
exactly.
not to a president.
Exactly. So the allegiance to the president and the oath to protect the Constitution, obviously the oath to protect the Constitution would override the issue of allegiance. Allegiance is only insofar as the president is doing the right thing. If he's doing the right thing, your allegiance is to the presidency, as it were, and as you put it. But if he goes off, your allegiance is not to the wrong deeds, but to him carrying out the functions of his office. You can't help
perpetuate illegalities or illegal orders or instructions.
Exactly. So we see a lot of things that are being ignored, that should not be ignored in this particular case. We see the president carrying out things that he ordinarily shouldn't. And I don't think he heeds to advice. Say there's a saying, an African proverb that says, you cannot convince a monkey that honey is sweeter than bananas. So this is a person who has his ways already fixed. His modus operandi, he's a businessman, so he looks at everything as a business. And you tell him this country is not a business, you don't run it as a business. Yes. And he won't budge into that because there are certain exigencies of the times that will require that you get maize and give to those that are vulnerable. Yes, because you have, because maybe there's a calamity such as a drought and all. You can't.
The country now knows who Makebi Zulu is. He's actually nowhere born on Christmas.
Yes,
you are a constitutional lawyer. We saw your debate during the Bill 10. You know, both sides discussing Bill 10. And just briefly speak, how are you a constitutional lawyer?
Well, my first degree was a general one from the University of Zambia. Thereafter, I got a master's in constitutional and administrative law from the University of Lusaka. I'm currently pursuing my doctorate.
Okay.
Yes, and obviously it's in constitutional law. And yes, that's how
that sets the stage.
Yes, exactly.
Before I go to the big issues, the country saw you graduating. What were you graduating from just early this year?
That was last year. I did. I went to Rema Bible Training College. I did a diploma in theology. Yes.
So do you want to walk back to a pastor, the life of a pastor? Why was that important?
No. It was just something that I needed to do for myself. See, when I'm studying law, I'm not doing that for myself. I'm doing that for
as a professional
clients like you.
Yes, correct.
I'm doing it for other people. But when it comes to Bible school, I think I was doing that for myself, for my spiritual man, my spirit man.
Okay.
Yes, just to enrich myself in the knowledge of
you
God.
are not becoming a reverend, a pastor.
No, I'm not becoming a pastor. I don't have that calling. I do not.
Never say that. Never say never.
I do not feel that calling.
Your father was. You may run away from it, and it may come one day. You never know.
Maybe he will become a lawyer as well.
Yeah. So let's get to the real business why I wanted you
please.
here. The state of the country. Yes. Like I stated, Amnesty International, the Human Rights International, the recent UN reports are all citing that there is, abuse of human rights in Zambia, that there is a dictatorship under formation, and that Zambia, which prides itself with its peace and security credentials, which prides itself as a democracy, that there is now total erosion. And there was hope that, remember, there were similar accusations against the previous government of President Edgar Lungu. Now those accusations are actually with intensity on President Hakainde Hichilema. What's the state of our democracy? What's the state of our human rights record?
I think the first problem that we must acknowledge is that we have a hypocrite for a president.
That's a very strong term to use.
Exactly, and I wish to substantiate it. And by saying a hypocrite, I do not mean it in a disdained way or mean to be malicious, but a hypocrite is obviously a person who says one thing and does another, and that has been very clear of our president. You have heard him on several occasions talking about the rule of law, upholding human rights. He's in charge of the executive, and the executive is charged with that responsibility to uphold or to ensure that the rights of citizens are upheld. On many occasions, the president has said that in the event that someone is arrested, I will pick this as the first example. In the event that someone is arrested, or indeed before they're an arrest, just ensure that you investigate, conclude your investigations, arrest, and if it's bondable, release them on bond. As I'm talking to you, we have one Thomas Ziambo, who's been in custody for over 12 days. He's not the first. We have had several other people that have been in custody for a period longer than the law prescribed. Now, what does the law prescribe, you may ask? In the event that you're apprehended today and you've not been charged, the police can only keep you for up to 48 hours. If they arrest you today and they charge you, the police have to present you before a court within 24 hours. Now, you would be a very good example. How many times have you been arrested?
Yeah.
And how long have you been in custody before you are presented before a court in the event that they deny you a bond? There are so many people that have suffered that.
The case of Thomas Ziambo,
yes,
I think it clearly is very distinct to demonstrate to the many cases that are suffering under the same issue. Thomas Ziambo was picked on 16th October.
Exactly.
Today is 31st. Exactly. It's actually about 16 days council.
Exactly.
He has not been given police bond. He has not been presented before court 16 days after the arrest. And counsel, his lawyers rushed to court for a habeas corpus application.
It's not a habeas corpus application, but for an application for bail. So
please explain.
The law is this. The law is this. If the police detain you and they don't bond you, as it were, they're supposed to present you before a court.
Yeah.
Any person who's arrested and has not been given bond can apply to the High Court for bond to be given, notwithstanding that the matter has not yet gone before court.
Oh, okay.
Issues to do with human rights, issues to do with freedoms of persons are supposed to be priority even before the courts. In this particular case, we have seen complacency on the part of the court. Because if a file is brought before a court and say, this is an application for bail, everything else should wait. An application for bail has got to do with the rights of an individual. An application for habeas corpus has got to do with the with rights of individuals, and these take precedence. Mm-hmm. Now, we have seen a situation where the police have refused or neglected to grant bail. You make an application before court. The file sits in a judge's chamber for a very long time. Mm. When that is supposed to be prioritized, that is very disheartening. Mm. That is very disheartening. And I can only blame this on the fact that the executive has been overreaching. Mm. So certain cases that are political in nature, it seems there is inertia on the part of the courts, because the courts, in my view, have been intimidated. They've been intimidated in that this president that we have has been so heavy-handed on the judiciary. Mm-hmm. The only president in a space of 3 years to fire 7 judges. And the reasons for the firing of these judges are quite interesting. Mm. Are quite interesting. I'll give you an example of Judge Muma, who is fired from being, or who's fired as judge for something that occurred before he became a judge. Mm. Mm. You have Judge Joshua Banda being fired for something that happened before he became a judge. Mm. We have an issue of Judge Katenekwa over an issue that can be dealt with administratively. In any event, he was due to retire in 5 months. 5 months before a judge retires, you decide to get rid of the judge. You decide to get rid of the judge just like that. And we have Judge Sandenkonde being fired for carrying out a judicial decision function. And within that judicial function, no one should be dealt with for carrying out a judicial function. The option that's available to a party is to appeal if you do not agree with the decision of a judge. And then we have a very incredible case of the 3 judges that recently got dismissed.
I want you to spend time on that. I want you to spend time on that. Yes. So clearly the state of our country is that there's erosion in democratic institutions. Yes. And that the autonomy for these, for the separation of powers to occur, like Parliament and the judiciary, is also blurred by the overreaching by the president.
It's not blurred. It's not there anymore. Blurry would be okay because there will be some semblance of it. But this time around, it is clearly targeted. I say it's targeted because the case in point is the issue to do with the 3 judges. Now,
let's delve into that.
Let's delve into this issue of the 3 judges as we're dealing with.
Just give a brief background.
Exactly. So in 2016, you have this petition that is presented before the court. And this petition is supposed to be determined in a period of 14 days. Now, within this period of 14 days, the parties are bringing up applications upon applications, and the last day for that application was to be the 2nd of September. Now, when the matter comes up on the 2nd of September, way close to midnight, the parties, Mr. Hakainde Chilema and his colleagues are abandoned by the lawyers, and then there's this issue, we need to get new lawyers, we're applying to get new lawyers, and the Attorney General stands and says, listen, there's this issue of them wanting new lawyers, but then this matter is limited. Within a period of 14 days, this matter must be dealt with, and dealt with conclusively. Now, every time the question of the jurisdiction of the court comes into play, that has to be dealt with first. And in dealing with that issue first, the court has to tell the parties whether or not it has jurisdiction to go beyond that particular period of time. And the application for these other guys is that, listen, we want to be heard, we want to hire other lawyers. The court at about 23:45 decides, okay, this is what's going to happen. We'll start on Monday and all. But even then, the issue of the jurisdiction of the court has not been dealt with because the Attorney General has raised this issue, meaning that it will have to be the first issue to be dealt with because it has been raised. Now, if you look at the ruling of the court went to do the right thing. When the matter came up on the 5th of September, they said, listen, we have considered. When this matter was adjourned, we have considered this issue. And every time an issue of jurisdiction arises, it has to be dealt with. We have looked at the law and the provisions of the law. And we are of the view that we are incapable of extending time that has been set by the Constitution. Yes. And because we're incapable of extending time that is set by the Constitution, our decision to say we shall hear you from Monday or on this particular day going forward cannot stand because that would be an abrogation of the Constitution. And because we have no jurisdiction, we will not go ahead to hear this matter. Now, this is a decision of the majority. The ones that dissent are Judge Chibomba and Judge Munalula. They say, listen, according to Judge Chibomba, she says, listen, this matter, the Constitution says the matter shall be heard within this particular period. It doesn't say heard and determined. But if the period in which it's supposed to be heard has expired, how do you go to determine? It meant that, okay, we didn't hear you within the 14 days. If I'm going to put her dissenting judgment in, we didn't hear you within 14 days. If we didn't hear you within 14 days, you can't extend the hearing. It means that after this period, you have to determine. What are you going to determine when there was no hearing? There's nothing. Assuming that she was correct, assuming that she was correct, that the 14 days is just for hearing, then for determination you can put another date. It would mean that this particular 14 days period, there must have been a hearing, not necessarily a determination that is going according to our argument. Then you can determine later. Okay. But if there was no hearing, how do you determine? It simply means she was also going to come to the conclusion that they no longer had jurisdiction because the jurisdiction to hear had since expired. Judge Mnalula's dissenting judgment was to the effect that, listen, the nation is at crossroads, and we can't rely on a technicality to stop this matter. That was a dissenting decision. But interestingly, I will show you that she seems to have gotten back on that point. She has shifted from that position because now we have the case of Electoral Commission of Zambia versus Belemu Sivanze, where she says you cannot enlarge the time that is set by the Constitution. Okay. Meanwhile, in the case for the 14 days, she's saying we could enlarge the time. So what is the difference? Yeah,
the case of Belem versus Isizet is a councillor from Cabo.
Exactly.
Who was convicted, I think, for some criminal offense. And Isizet is arguing that the election should take place within the stipulated 90 days.
Yes.
But in relation to this, Judge Munalula has now ruled with the Constitutional Court that time is immutable. It should take place in 90 days.
Exactly.
But before that, on the 14 days, in regard to the UPND petition, she was saying you could vary it in national interest.
Exactly. That's what she says. She says you can't rely on a technicality.
May you read what she said?
Let me read what she said so that I put it in context. If you look at her dissenting judgment, which I have occasion to read, on page 7, she says, in my view, therefore, the parties to this case working with this court would have helped this country by allowing a hearing to take place rather than make a pronouncement based on a technicality.
The 14 days, she called it a technicality.
Exactly. She called it a technicality. And she says this country would have been helped if the parties she allowed a hearing. Now, if the Constitution says the matter should be heard within 14 days, who are you to extend the time that is set by the Constitution? And in this Swanza case, in the ruling, she says, no, you can't, because the time has been set by the Constitution. And as authority, the court is relying on the very case of Hakainde Hichilema and Geoffrey Mwamba versus Edgar Chagwa Lungu. As this is our authority, meaning that that decision was the correct decision.
Dissenting view.
But then you have people that are being punished for making a correct decision that is being followed by the Constitutional Court.
Now, as soon as that hearing, as soon as that ruling took place,
yes,
and the petition was therefore dismissed, the UPND raised complaints against the judges. Yes. They said the judges must not have stuck to the 14 days that President Hakainde Hichilema was not given an opportunity to be heard. And there were various petitions before the JCC. Yes. What was the fate of those petitions against the JCC that was taken to the JCC against the judges of the Constitutional Court? Okay.
Now, these charges were raised against the judges. All the judges that sat, the 5 of them, as it were. And the complaints having been raised, all the judges responded to those issues. And having responded to those issues, the Judicial Complaints Commission came up with a decision. And I would like to read the conclusion so that I put it in context. Now, the conclusion of the Judicial Complaints Commission was this. The respondents were inconsistent in some respect, but in our view, that did not amount to incompetence or gross misconduct. Admittedly, they did not pronounce themselves formally on the interpretation of Article 1015, but we are satisfied that their directions to the parties were based on the interpretation of the article. Further, the fact that the respondents came up with 2 split decisions did not amount to incompetence or gross misconduct, because this was a mere difference of opinions. A difference of opinion, as stated above, does not amount to incompetence or gross misconduct. We find that none of the findings of fact amounted to incompetence or gross misconduct under Article 143. We therefore find no prima facie case against the respondents. Now, this was the finding of the Judicial Complaints Commission there. Yeah. Not once, not twice, not even 3 times. This was on the 13th of October 2017 when they passed this. Now, 6 times, there were 6 complaints, and in all those 6 complaints, they came up to this particular conclusion. Now, the issue is, they found no prima facie case. Yeah. Fast forward, 5 years passes. We are now in 2024, which is pretty much 8 years after the fact. We have new complaints. The first complaint was immediately after UPND won. Busenga complains to the commission and says, we need to bring back that case. Then we have State Counsel Vincent Malambo saying, as chairman of Judicial Complaints Commission, saying, we can't reopen that matter because of issue estoppel. Now, issue estoppel is that the issue has already been dealt with. We can't reopen it. And he explains and says it has been dealt with several times and it cannot be reopened now. Yeah. The person who complains renews the complaint again. And for the second time, he says, no, we can't reopen this complaint. Fast forward, Moses Kalonde comes and makes the same complaint. Now, with the appointment of these new commissioners, Eva Jala and former Judge Nyambe, they come on and say, no, we are going to hear this matter. Obviously, this matter and the complaint ordinarily is supposed to be against all of them. But the complaint was only against those that decided against Hakainde Hichilema. And Hakainde Hichilema had
spared the ones that gave dissenting
views. Now, and President Hakainde Hichilema had already expressed his view as regards these judges. Remember, After that 14-day saga went, he referred to them as criminals in robes.
Yes.
Okay?
He issued that very contemptuous statement that they were criminals
issued that
in robes.
very contemptuous statement saying they were criminals in robes. And he has never moved or departed from that position. It is something that he showed that he had an interest. And if any matter was brought before him as regards this three, there's no way he could have acted fairly or impartially. There was absolutely no way. Now, with the surrogate of the UPND, in one Moses Kalonde, coming to complain, it is obviously an instruction, possibly an instruction from the party's rank and file, if not from himself, to say, bring this thing up. And it's obvious right from the start. After the first issue was raised, to say, listen, this matter has already been heard and determined. You can't hear this matter. The Judicial Complaints Commission decided, no, we are going to proceed and hear this matter. It was obvious at that stage that their fate was already sealed. It was very obvious.
They're just being pushed through
just fulfilling all
emotion.
righteousness, just going through the motions for purposes of getting rid of them. Because if
does the JCC have powers to reopen or not a case like this?
They do not have that power to reopen. They tried to distinguish it, the complaints from
by
the others,
saying
but
there was a new
went,
issue of qualifications.
Even the new issue of qualifications, they do not necessarily deal with it. They deal with the substance of the fact that you dealt with this matter, you sat over a weekend, and very, very strange, if not ridiculous reasoning that is there. Because they even go outside their mandate and they start interpreting the Constitution. The JCC has no role whatsoever to play in the interpretation of the Constitution. That's a preserve of the Constitutional Court. They interpret the Constitution, and it's quite curious. I'd like to refer to that particular part where they make certain findings. And I don't want
where
to
they interpret the Constitution.
Yes. I do not want to be seen to be speaking from without. Yeah. If you look at page 32 of their ruling, and it's very interesting. For the first time, issues that relate to the Judicial Complaints Commission are being made public. Yes, and it was obviously a deliberate move. You have never seen any report relating to any judge that has been removed from that position, apart from these three judges. It is a very curious issue, and in this particular,
there's an issue of security of tenure that is clearly threatened for judges in as demonstrated in the three constitutional court. That within a period of 2 weeks, it doesn't matter whether you're a constitutional court judge, Supreme Court judge, High Court judge, you can be removed in a period of 2 weeks. Where is a tribunal of 3 High Court judges? I ask this because previously, before the new constitution, it was required under Judicial Complaints Authority that the members of the Judicial Complaints Authority could only convene a tribunal. They would seek authority from the president, who would then convene a tribunal for such a judge to be heard, and then the recommendations to go to the president for determinations. Why are we not seeing those 3 judges sitting to determine the fate of the judges? Why is it? Are those judicial? Are those members of the JCC judges? Do they have adjudicating powers? Can they hear and determine and make recommendations to the president?
You ask very interesting questions, but after the change of the Constitution, we have not had a change to the Judicial Complaints Authority Act. What we expect right now is that we're supposed to enact the Judicial Complaints Commission Act. That has not been done as yet. Perhaps if that is done, it may bring in some sanity and some clarity to what exactly should go on.
So we have the provisions. Just a minute, Council, because Mulelandana want to ordinary people, you educate us.
Yes.
So in the Constitution, there's a body called Judicial Complaints Commission.
Yes.
The enabling legislation is the old one, Judicial Complaints Authority, the one that provided for the 3 judges.
The one that provided for the 3 judges was the Constitution, but of course, it had to be in line with the Judicial Complaints Authority had to be in line with the previous constitution.
Yeah.
Now that there is no Judicial Complaints Commission Act, the Judicial Complaints Authority Act continues.
It is acting as an enabling legislation
it continues,
for this new body.
Exactly. It continues with the successor body until there is a change.
Okay.
Yes, until there is a change. But
so why are they not following the provisions of 3 tribunals? Why are they adjudicating like they are judges?
You will note that in the discharge of their functions, and the ones that have done a disservice to themselves, is the court itself, the Constitutional Court in particular. Because at the times when these issues have been raised before the Constitutional Court has chosen to erode that security of tenure of judges. Perhaps it's an issue...
Just explain the previous complaint about this disconnect.
Yes. So the issue has been where the court has had occasion to determine issues that relate to the procedure to be followed. In the wake of the commission, as it were, you had the case of Seyuniwo's DPP, and the law provides that her removal should be in substantial conformity in the manner in which you remove a judge, meaning that it's possibly the same commission that will have to deal with this issue. Now, a petition is presented before the Constitutional Court. Now, oblivious as to what exactly should be the purposive approach in determining the interpretation of the Constitution. What is it that a democracy aspires to have in that particular sense has to be considered and has to be looked at. And in looking at the requirements of the Constitution and looking at the requirements in a democracy, you have to interpret the Constitution in such a way that the tenure of a judge is protected.
Yeah.
They neglected to do that. They neglected to do that and gave the president so much power to be able to decide anything. Because even then, there would be issues of a recommendation from the Judicial Complaints Commission. But notwithstanding what the recommendation may be, the president can make any decision.
Oh, I see.
It doesn't say,
it's just the recommendation.
Yes, it doesn't say that he is bound by the recommendation. Even in the event that the Judicial Complaints Commission is of the opinion that they didn't do anything, the president can say, I don't like them. You've recommended, go away. You see that? So there is nothing that suggests that the president is bound by the recommendation, as it were. There is nothing that ensures that the security of tenure of the judges is secured.
Yeah.
And all the blame goes to the Constitutional Court itself for the manner in which they have chosen to interpret the Constitution, and interpreted it in that particular case, not in a manner that furthers its objectives, but waters down its objectives. Because you can't move from a position that was strong in the manner in which you're going to remove a judge, a position that was very rigorous, a position that was very rigorous, and you have a new constitution and you interpret it in such a way that it waters the very essence and purpose of the constitution. That is not what was intended. But that is exactly what happens. Now you see that in this particular new ruling of the JCC, they purport to say, no, Judge Mwamba came and testified this and testified that. But if you look at the testimony of Judge Mwamba, in the 2016, what she submitted, and she was saying that we did nothing wrong. That was her submission. They called her as a witness now, and they're bringing up new facts. You'll be curious. Let me just read some excerpts of what Judge Mwamba said in the previous tribunal. And what she submitted, let me just get to that. Okay. So Judge Mwamba, in her submission as to how the issues were to be dealt with, and how that as a constitutional court they did nothing wrong, had this to say. She says, constitutional matters, that's on page 3 of our response, she says, constitutional matters are complex and may, such as the presidential election petition was, be conducted by the parties in a highly charged atmosphere. As judges of the Constitutional Court, we were aware and alert of the huge responsibility the people of Zambia had placed and entrusted us with. We took judicial notice of the tense political atmosphere that engulfed the country towards the close of 2nd September 2016 and the uncooperative behavior of counsel for the parties. The record will attest that the petitioners' lawyers applied to be removed from representing their clients around 22 hours, and the hearing had not commenced at that time. The petitioners then applied for time to secure alternative legal representation, which they are constitutionally entitled to. It was counsel of prudence in the circumstances that we decided to adjourn the case as the exigency of the situation so demanded. The case was accordingly adjourned to Monday, 5th September 2016. As a court mandated to nurture the development of the law and contribute to good governance under Article 2671 of the Constitution, it was not legally wrong to adjourn the matter in the manner we did. On resumption of the sitting on 5th September 2016, the majority decision to terminate the proceedings prevailed. The effect of the majority judgment is that the petition lapsed and the decision henceforth became binding on the parties. But I want you to hear this part. She says, I must add that the dissenting opinions of the court are immensely helpful in the development of the law. It is for this reason that the Constitution provides for sittings of the court in panels of an even number of judges, so that in the event of failure to reach unanimity, the majority decision prevails. I'm aware of dissenting opinions, decisions made by the Supreme Court in Zambia and by its predecessor, the Court of Appeal. And the practice is commonplace in other democratic jurisdictions. Minority decisions play a very important role in law reform, development of local jurisprudence, and academic enrichment. Now, this is what Judge Mwamba is submitting to say it is okay. Now we have this issue of saying, actually they sat on a Saturday. They sat on this particular day. There is nothing wrong with when you are going to sit to make a decision. The issue is it the majority decision? You can sit in heaven, in hell, under a tree, on a rooftop, on a weekend, on a holiday.
They're being accused that they sat alone, the three sat alone.
Even assuming that you are going to be on your own. The thing is, it is the decision of the individual judges which should form the majority decision that should prevail. Whether you're going to sit the two of you, the three of you, even two can disagree. But in this particular case, the majority said, no, time has lapsed. Now, if we're going to take it for granted that, okay, fine, the two or three sat, or the two sat and made that decision, and then a third person who did not sit with them agrees with them, and then you punish him for agreeing with the two that purportedly sat over the weekend, and you say he was unprofessional to agree with the two who sat over the weekend. You are suggesting...
Is it unprofessional
to
make a judicial opinion, a judge's opinion?
It is not unprofessional. As a matter of fact, the idea of having them in even numbers is that each of them makes a decision. If I make a decision and I agree with you, I'll ask you, what is your opinion? And there's nothing that says, okay, this can only be discussed when we meet, when the judge president says, come. I can come to your chambers and say, okay, there's this matter we are dealing with. My opinion is this. What do you think? If you have an alternative opinion, I should be in a position to either convince you. If I'm not able to convince you, you stick to your opinion. You may convince me, or I may stick to my opinion if I'm not convinced. So in this particular case, it doesn't matter when or where they sit. But the curious thing is that when the matter came up on Monday, there was a majority decision, And there were dissenting decisions. At what time did they know that there was a different decision from the three? For them to be able to write their dissenting decisions. It means that they were aware of the decisions of the others for them to be able to write dissenting decisions. You even call it a
dissenting view.
Exactly.
Because you can't know that it will be dissenting.
Know, exactly. Otherwise, I would have been shocked to just show up in court and say, okay, we have a ruling on our end and we are going to deliver it. And you'd be shocked. But then these people come and they're in court and saying, okay, this is a ruling of this court as regards this matter. Immediately they finish, you say, I'm going to read my dissenting opinion. You must have been aware. However you become aware is not an issue for the consumption of any other. But this Judicial Complaints Commission seems to suggest how they should be sitting to make a decision. No, this is a collegiate decision. Well, the judge president was wrong to allow them to do that. The thinking of the Judicial Complaints Commission is that the judge president has got power to force a decision on the judges.
Highly regular.
Because I'm judge president, I'm going to sit and say, we are going to go in this direction. They will say, no, we will not go in that direction.
The powers of judge president, do they extend to disrupting?
The powers of the judge president are essentially administrative.
He's a chair to coordinate.
Yes, he's a chair to coordinate. The judicial decisions are for the individual judges. The individual judges will make decisions, and then if three of them agree, they'll say, the three of us agree. What are your reasons? And they'll say, okay, the reasons. If the reasons are the same, they'll write one judgment. I can also say, I agree with you, but for different reasons. And I'll be able to write my judgment saying, I agree with this position, but not for the reasons they've advanced, but for these reasons. Or I can say, I disagree with your position for these reasons. Even the ones that disagree with each other, I'm able to say, okay, I disagree, but not for the reasons the other person disagrees, but for my own reasons. In this particular case, we have Judge Chibomba disagreeing with the majority decisions.
But she has her own
reasons. We have Judge Mnalula disagreeing with the decision of the majority, but with her own reasons. And these reasons are not even the same with the reasons for Judge Chibomba. So that is how the court is supposed to function. That is how we're supposed to improve our jurisprudence.
The judges have been removed on two key issues, according to the judgment. Number one is that they are judicial decisions and they're being accused of having sat alone and they've categorized it as misconduct. Number two, that they are not qualified to hold that position of judge.
You see,
speak to that. How is it possible for a judge who's been sitting at the court for the last 8-9 years all of a sudden be unqualified?
The question is, can the Judicial Complaints Commission overturn the decision of the National Assembly when they ratified that appointment?
Because in effect, that's what the JCC has done.
If there is an appointment that has been made, and the whole issue goes through the mill, okay? And there's a decision that these are properly in place. What you do in that particular case, the Judicial Complaints Commission should have gone to court to challenge the qualification of those, in the manner that we challenge the qualification of Judge Shilimi. Because Judge Shilimi has no experience in constitutional law. He has no experience in human rights. The only thing that is stated in his CV is that there's a module he did in his international law studies, international human rights law. There's a module. And the court ruled that, listen, he has sufficient experience. That is not a decision for the Judicial Complaints Commission. They can't make a decision as to the qualification. They can't make that decision.
But that's what they pronounced.
Yes, if they are going to make that pronouncement, it means that they are interpreting the provisions of the Constitution, and they have no such mandate. They don't have that mandate. So we have a system that has broken down only to feed the ego of one person, and that is President Hakainde Hichilema. And if he could realize that the functioning of a democracy requires that state institutions only work to advance the democracy of a country, not to take away from it. All these organs of governance, Human Rights Commission, Judicial Complaints Commission, Judicial Service Commission, all commissions, as it were, are intended to enhance the rights of citizens, not to take away from them. They're intended to enhance democratic credentials of the country, not to take away from them. You may be curious to note that when it comes to ACC, the funding in the last budget has, to this year's budget, the budget that was announced, has decreased. Or if there's minimal change. But the funding to the Judicial Complaints Commission has increased exponentially.
My God.
By about over 40%.
My God.
That's the funding that has gone to the Judicial Complaints Commission. Why would you underfund the Human Rights Commission? You underfund
even the
ACC, the police, the Drug Enforcement Commission. But when it comes to the Judicial Complaints Commission, you increase the funding by 40%. Why don't you increase this funding to the judiciary, for example? Increase it by 40%, make them financially independent, and you'll be able to do you'll be able to be seen to be trying to protect the values of democracy and human rights. But here you are going to overfund an institution that is intended to discipline, to remove judges. You are enabling them to be able to effectively remove those that you do not want. The problem
do they have powers of adjudication? You didn't answer that question.
Listen, they have powers to determine complaints that are presented before them that relate to misconduct of a judge and that relate to incompetence of a judge. Now, in dealing with misconduct and incompetence, it has got nothing to do with the judicial function of a judge. Because the judicial function of a judge, it's recognized that there's a chance that a judge may be wrong. And within that, we have said, let us give room for appeal. Otherwise, there would be no room for appeal. The role of the Judicial Complaints Commission is not to correct the judgments of the court in the manner that they are hoping to correct this particular judgment. It's not to review the judgment of the court in the manner that they are reviewing the judgments of the court, in which they are suggesting that the majority decision should have been that it was wrong, it was incompetent, there was misconduct on the part of the judges. There was nothing of that sort. They are choosing to rewrite a judgment that was a judicial function of the judiciary and replace it with their own, which effectively can't be implemented. So they cannot go outside the bounds of determining the incompetence or misconduct of a judge in the personal capacity. But when it comes to judicial decisions, they cannot delve into the correctness or wrongfulness of a decision that has been made.
Do they have powers to reopen the case in the manner that they did? And as a rider to that, I have seen in their final report that they are condemning their own chairperson, Vincent Mwamba, and they've cited him.
You see, that is what would amount to misconduct. Because in these proceedings, we see nowhere where Vincent Mwamba is called.
He's a subject, yes.
No, where he's called in the first place, to be heard as to why he made that decision. So this has been a strange happening, where you find decisions that are condemning persons that have not been heard.
Yes.
That are condemning decisions where the subjects of those decisions have not been heard. It is very strange. We see nowhere where they're saying Vincent Mwamba comes. As a matter of fact, they're saying that Vincent Mwamba misconducted himself. Yes. As a matter of fact, I would expect
Why did they say that? Why would you say that about the chairperson?
I would expect that the president removes Vincent Mwamba.
Yes, that's what it
Better
is.
yet, I would expect that Vincent Mwamba resigns because their commission itself says he has misconducted himself. Not once, but twice. He refused to reopen.
Is punishable.
Exactly, and misconduct is punishable. As a matter of fact, that is what would be classified as incompetence. They're saying that he was incompetent to do so. And by doing so, he misconducted himself. Why is he still there?
Yeah.
Why is he still there? Why hasn't he seen the back door? Why is he still part of the commission? Are they suggesting that they are there as instruments of punishment for and on behalf of President Hakainde Hichilema? Is there any integrity that is left in him to say, okay, I have been found wanting, so I must resign? But obviously he will not, because he will obviously say, I was not given an opportunity to be heard. So if they are questionable on a decision that relates to Vincent Malambo, why should we trust them with a decision that relates to the three judges?
Yes, correct.
We can't trust them. We might as well trash their decision and say that the president obviously acted because that has been his desire all along. I think he has misdirected himself on many fronts, not just on the economic front, but on the front that has to do with issues of separation of powers, but also policy when it comes to international relations. In a very long period of time, we are finding ourselves where we are not seemingly getting along with Zimbabwe. We're not seemingly getting along with some of our neighbors. What is happening to our country? What is happening to our foreign policy? What is happening to our economic policy? What is happening to the observance of human rights? What is happening to the observance of the rule of law in this country? We're looking at all these things, and everything is stopping at the president. Is there anyone who is helping the president do the right thing? But like I said, you can never convince a monkey that honey is sweeter than bananas. He seems to have his own modus operandi, such that when you tell him you can't do this, he asks, why not? I'm president, I can do all things. He's fixed in his ways.
He actually expresses frustrations all the time.
Exactly.
That people are steeped in bureaucracy and they wouldn't allow him to move. He doesn't seem to respect rules and regulations.
Exactly.
Another matter related to this, before I let you go, Counsel, is the issue of another reopening of a major case, the case of eligibility for the former president, Edgar Lungu. This matter was settled several times. I don't know how many times it was settled, you tell us. But the part I'm interested in, because you're appearing before the same court and you may not discuss particular details, the part I'm interested in was this pronouncement by the court, especially by the judge president on you, trying to send you to Laz. But before you answer that, speak to the issue. Can you reopen case? It has become fashionable. Here, JCC reopened the case as soon as they had new commissioners in Evajala, and other two members of the new commission. They reopened the case for the three judges, and we've seen an adverse decision. We are now faced with the eligibility case of President Lungu. Even if it has been settled by the same court, and in many cases, same judges, other than a few that have joined it, it has been reopened. And then you had made this application for their recusal, and then they made those rulings on that. So you have those three questions.
It's a loaded question.
Yeah, let's start with
it's a very loaded question. But
how many times has this case been heard and settled?
Yeah, but just for purposes of context, decisions that are made by institutions are decisions for the institutions and not the individuals that are there.
Occupying it.
We can't have a situation where a decision changes depending on who is
the new
there
office holder
as an office holder. We have seen the decision of the Attorney General changing because there has been a change of office bearers in the eligibility case. And we had occasion to argue before the court. So this court is not like the Attorney General's chambers who are flip-flopping. Even when ordinary, they shouldn't be flip-flopping. And the very important issue is that there must be certainty in the law, where if there's a decision that is made and you have a similar set of facts, you must be able to know that there's predictability in the manner that the court is going to make decisions. If there's no certainty or predictability in the manner that the court is going to make its decision, that's only a recipe for chaos. It's a recipe for chaos because the trust in the system will be eroded. Even the very things that President Hakainde Hichilema says he wishes to bring, such as foreign investment, maybe it explains as to why the promise for foreign investment is not coming in, because one of the things that an investor looks at is how is the dispute resolution mechanism of your country. Do your courts follow the law as it is? Is there certainty in the manner that they settle their disputes?
Yeah.
If they have problems with that, they will not come. If they think that your courts are capable of being manipulated to decide in a certain way, they will not come. Perhaps it explains the economic downturn that we have, because everything that has been done by this government has been to the extent that you can no longer trust our institutions of governance, you can no longer trust, or there's diminished trust in the certainty and predictability of the courts. And that is trickling down to organs such as the JCC. Now, we are awaiting the judgment on the 10th of December. It will be curious to see that there's a shift in position. Curious because in the Danpule case, in the way we argued, we said you made it very clear in no uncertain terms that he was eligible. In the case of Bampika Palasa, you re-emphasized that particular position and said, we have already decided one too many times that he is eligible. Then came the Sishua case, as well as the Legal Resources Foundation case, which were put together, and the decision was made. And the court even warned in that case and said, listen, it should not be the practice that you keep pressing a matter on an issue that has already been resolved, hoping to get a different result. You can't do that. So when this matter came up the 5th time, because I'm counting the Sishua case and the Legal Resources Foundation, yes, as two cases that were consolidated. The 5th time now it comes up, we say, listen, on a preliminary issue, you have dealt with this matter, and you can't be seen to be reopening this matter. And now we have argued. They said, okay, you have raised this in your defense, and we'll hear you, and we'll hear what the other party has to say. And we went and argued to say, even though these people want you to reverse your decision in this particular case, they have not prayed for that answer. They've not asked you specifically to say, reverse this decision that you've made. And of course, we've argued other matters. And we're looking forward to see whether the court will remain certain, whether the court will not behave like the Judicial Complaints Commission. We are yet to see that on the 10th of December. We are hoping that they do not behave like the Judicial Complaints Commission. We're hoping that they're able to stand by the decisions that they made 4 times before. Yes, we're hoping for that. And you asked a very interesting issue as to the question.
You had an application. Yes, you had an application of recusal.
An application for recusal.
I think that's a normal application in any normal matter. See, you felt that the 3 judges were conflicted, and you raised a petition, but the answer was an angry answer. Even the judge president asking the Attorney General to refer you to LAS. Was there anything wrong with raising the recusal?
The reason the law has provided for applications for recusal is because the law envisages that there will be situations where that application will be necessary. And this was one of them. This was one of them because the apprehensions of a person that is going before the judiciary have to be taken care of in the light of having a fair hearing. A fair hearing is guaranteed by the Constitution. Every person should have a fair hearing. Any departure from that, even a perception of a departure from it, should be avoided. And this application is brought. And we're saying, listen, there is a close association between you, Judge Shilimi, and President Hakainde Hichilema, who is likely to be a beneficiary of these proceedings. And we think it may not be a good thing for you to sit. Our client is apprehensive that you may not be perceived to be impartial. Now, the issue is not whether actually the person may be partial, but the perception of it is sufficient. Now, the the ruling comes, and he says, yes, there is a connection, but it's remote. And we're saying the very fact that the connection is there, no matter how remote, is sufficient ground for one to recuse themselves. And the person says, no, it's remote, I will not. Okay, I will not recuse myself. Now, I think the judge should have gone further and says, although I'm of the view that the connection is remote, I will recuse myself for purposes of the perception, not being that I may not act in this manner. My view is that it should not have gone further to say, I will therefore sit. It shouldn't have been.
After establishing
exactly
a link, although he deemed it himself to be remote.
Exactly.
But he then chose to sit on the case.
Yes, chose to sit on the case. And the ruling by Judge Mnalula, it was a very, very interesting ruling. We were representing a client who had certain concerns.
She used the word modus operandi.
Yes.
She says, every time I've sat in your case, your law firm, Makebi Zulu, you seem to have created a modus operandi where, you want me to recuse myself.
And then she says, why me?
Why me?
Exactly. No, I read that ruling. It was a very interesting ruling. But perhaps for
our viewers,
and for perception to the whole issue. See, previously in the Milingolungu case, there was an application that was made before the court. And I did not think that she would go that far to isolate the lawyers and deal with the lawyers in the manner that she did. If she intended to go in that direction, during the time we were submitting, she should have at least asked us to say, listen, why is it that you are so concerned about my sitting here? In that other case, you made a similar application
of recusal.
Of recusal. Is this your modus operandi? We would have been heard. We would have explained to her, would have explained to the court that no, this is not our modus operandi. In that particular case, we acted this way because of these circumstances and these facts that we're faced with. And it was necessary to protect the interests of our client to be able to delve into that issue and make that application which we make. But to come in this particular ruling and make such pronouncements and that ruling becomes part of the record is pretty much unfair because we were not heard. And no party should be condemned unheard.
No, when there was an application for recusal, we were hearing issues of the recusal.
Exactly.
So, but in the judgment, the judge brought past issues.
Yes,
that
past issues.
You even in the other case, you applied on the recusal.
Now, let me tell you something that happened in the other case. There was a motion that was raised. The motion that was supposed to be heard. And State Counsel Sakwiva Skota was leading the team. Okay, so it is not correct that it is our firm because there are 3 firms that were involved in that particular case. We were part of that case. And in that case, when the motion was filed, the matter came up before court. And it was brought to the attention of the court to say, we can't proceed with the main matter because there's this motion that has been raised. There and then, herself being the person that was presiding over those proceedings says, no, we will not go ahead to hear that motion. She made a ruling against that particular motion. So it was shocking. It was pretty much shocking. And the court was asked to say, let's retire to chambers and discuss this matter. That was granted. And when the matter came up in chambers, it was presented to them to say, listen, you can't throw out this application without hearing it. You can't throw it out without hearing it. Because we are of the view that the opinions of the other judges on the panel was not taken into account. So at that point, the court itself decided, okay, we are going to hear your application. We will hear this matter. And concern was raised to say, okay, you have already expressed your opinion over this matter. You threw it out before hearing it.
Yeah.
Therefore, you can't sit. That issue was raised. And in that matter, when the motion came up, she didn't sit because she had already expressed her opinion on the matter. So if it's that issue that she was referring to, we had justifiable cause to raise the issue because she made a decision, in our view, without consulting the other judges that were on the panel, and she expressed her opinion even before hearing the parties. And that was not correct by any stretch of imagination. That was certainly not correct. And obviously, that would lead anyone in that matter to say, no, there's a perception of bias on your part. You don't like me. You don't like the way I'm proceeding in this matter. And therefore, I don't think you should be sitting in a matter. So that is what happened in that case.
No, the two issues were conflated.
Exactly.
I think they were not the same, and there was no justification to import it into that ruling. But they were terribly emotional. As soon as I read the three and their justification, I said, that's a reason they should actually recuse themselves.
As a matter of fact, that should have been the reason. The very fact that in fact, it is a provision of the law. If you're uncomfortable with a lawyer for a litigant, and you have issues with a lawyer for the litigant, that should be reason enough to say, I will not. Otherwise, you'll make a decision hoping to punish the lawyer for the litigant when it's affecting the litigant and not the lawyer necessarily. So that, in my view, should not have been part of that. Firstly, because we were not heard on that particular application. Secondly, because it gave a perception that she had problems with the lawyers. And as such, she may be perceived not to make a correct decision on the fact that she has problems with the lawyers. And that should have been reason enough for her to recuse herself.
So what will happen to the judiciary with the dismissal of these three judges who are now total 7, with the reopening of odd cases that by all legal standards are deemed determined and settled. But now there is no guarantee that a matter against anyone can be reopened and reheard. What's the status of the judiciary?
Unfortunately, that seems to be the precedent that is being set. And it will be sealed based on what the decision is going to be on the 10th of December. So we're curious to see what the decision is going to be on the 10th of December. In which case, all lawyers should be ready to say, okay, that matter where the Supreme Court or indeed the Constitutional Court made that decision, we can always go back and have them change their mind. If they don't change their mind this time around, we'll commence another action. If they don't make a different decision, we'll go ad infinitum. And that really kills the issue of a matter being res judicata. Res judicata is a legal concept that means that matters should be settled with finality and that you can't keep dragging the same person to court over and over and over again over the same issues. There must be finality to the resolution of issues. That is what...
I saw the Attorney General argue very, very strongly that the court has powers to review its own decisions. Does the court have powers to review those decisions?
See, the court has power to review its own decisions. That we can't take away from the court, the power to review its own decisions. But there must be a specific application made to the court to review that decision. Or in circumstances where another matter arises, the court can reverse their previous decision based on the law existing at that time, or indeed there's fresh information that has come to their attention, which may not have been there at that particular time. But in this particular case, none of those issues exist. The Constitutional Court, in more cases than many, has pronounced itself to say, we are bound by our own decisions. And they have to put that into practice. We'll see if that happens on the 10th of December.
They'll be bound by their own previous decisions.
Exactly.
Council, there are many things I want to speak to you about, especially because of what is happening. Recently, the Electoral Reform, the Electoral Commission of Zambia, Chairperson Mwangala Zalomis, appointed an Electoral Reform Technical Committee to review the constitution and legal provisions that hinder her work as ECZ. I found that very, very strange. First of all, ECZ and Mwangala Zalomis are creatures of the Constitution. Do they have powers to set up committees to begin to hear reforms to themselves? I say this because previously, any reforms have been driven by either the president through the Commission of Inquiry or through the Zambia Law Development Commission, where they would make recommendations. But here now we have a body in ECZ where Mwangala Zalomis has appointed the Electoral Reform Technical Committee and set them out in the country to gather views about what they think about the constitution in relation to elections, what they think about the law in relation to elections, what they think about her body ECZ, and she wants to make recommendations for the law.
Okay.
There's another matter happening in Parliament where also the Speaker seems to have started a process to amend the Constitution on the so-called non-contentious issues. What is happening to our law reform? Is that how it is done?
You see, that's why I keep telling you that it is difficult to convince a monkey that honey is sweeter than bananas. The very fact that President Hakainde Hichilema thinks he has control over all these institutions, it's difficult to tell him that you can't do this because he thinks it's a company, I'm the CEO, therefore I call all the shots. You can't run a country like an enterprise. I was running Eastern Province. I knew where my bounds were, where the line ministry works and does its job, and where I come in to supervise the works that are being done by the line ministries. It did not put me in charge of the line ministries. I could not make a decision that was contrary to the decision that has been made by a minister in a line ministry. Although those ministries were under my domain in the Eastern Province, the decisions of the local authorities, those were under my supervision, but I could not replace my decision for theirs, or their decision for mine. So there are limits as to what can be done. Institutions of governance are governed by the statutes that creates them. And in this particular case, you have the Electoral Commission of Zambia, which is regulated by its act, as well as the Constitution. And everything that they do has to do with what is provided in the law. There's nowhere in the law where they said they have a right to make recommendations as to how best they can carry out the functions of their office. Where there's that power, it is specifically provided for. Now you have the Law Development Commission, you have the Minister of Justice, you have all stakeholders that have a part to play in what the Electoral Commission of Zambia does. And the essence of the Electoral Commission of Zambia is to carry out elections in a free and fair manner, in a manner that satisfies the will or promotes the will of the people, promotes democracy, promotes the rule of law. To assume a power that you do not have, to say we are going to collect views as to how best we can work better as a commission. You are saying we have failed to work within the mandate that has been
provided for.
And we are going to get views from around the country as to how we should work. Have you told us how you have failed in the first place? What is not working there? Why are you going to collect views when you are the ones that are having problems with how you're working? Why are you collecting views? You're collecting views from people that are not working there. But in the meantime, the way that you're operating is what the Zambian people have decided is the way you are going to operate. Your competencies can only go so far. This is the power that we're giving to you.
Yeah.
And you are going to the people to beg to extend your power to do what you think you must be doing. How did the previous or successive commissions perform within the limits of the power that was given to them? What were the failures? They have not told us. In any event, I did not see anything in the budget line for Electoral Commission of Zambia to carry out that particular investigation exercise. So who is funding it? How is it being funded? Where are the monies coming from? Is it another issue of abuse of office? Is it another issue that will be a subject of investigation at some time in the near future? Where is whoever is in charge of the commission getting this power to carry out these functions? I think that should be an issue that should be interrogated. And they can't do that without the blessing of the executive. And they are doing so wholly with the blessing of the executive. And
illegally
the executive,
so.
Exactly, and illegally so. Even when it comes to the National Assembly, the Constitution is a document for the people. Nothing emanates from the National Assembly. The National Assembly receives and deals with matters. Nelly Muti cannot, on her own accord, say, we need to amend the Constitution. She has no such power. All that power is reserved in the people. All that power has to come from the people. The need to amend must come from
there.
The people. Yes, from there. I know of no legislation that first emanated from National Assembly. It has to be moved by the executive. If not by the executive, it must be moved by a backbencher. If not by a backbencher, as a citizen, I can petition the National Assembly, petition that a certain law be enacted. I could do that, and that is obvious, has to be done by the members of Parliament, and not the Speaker of the National Assembly. They are not the author of any law. Neither are they the omega of any law.
No, they forget they are mere presiding
Exactly.
officers. They think the powers of the Speaker extends to doing the jobs of MPs.
Exactly. So to preside over a matter does not mean you initiate the matter. You preside. You're a referee. You can't have a referee going to say, okay, next week is Zambia versus Morocco playing. You're going outside your bounds.
Yeah.
Your job is to get the instructions. Okay, Zambia and Morocco are going to play. You are going to officiate.
Yeah.
Your role is simply to officiate and not to start. So it's a rogue parliament that we have. It's a rogue parliament that we have, and we need to bring it back to where it's supposed to be.
And finally, the state of human rights. You know, these arbitrary arrests, extrajudicial killings, long detentions,
freedom of expression,
and then the freedom of expression is
freedom of association.
Yeah.
Yes, we have those problems, and there's nothing that the president can say, what information minister can say, PS information can say, that would take away from the fact that Zambians have seen that there's been an erosion of the freedom of expression. For the first time in this country, we have seen more cases of seditious practices, a matter that is being used to stifle dissent. Yeah. The very fact that you do not like what a citizen has said does not mean they've committed an offense. The very fact that a member of the executive disagrees with my opinion does not mean that then I've committed an offense. But it appears that if a UPND cadre disagrees with the position that has been expressed by a member of the opposition, they'll go to the nearest police, and it's seditious practices. That is what has been going on around. And the trouble is, all the watchdog institutions, the CSOs that used to speak on behalf of people, have suddenly gone to sleep.
They're dead.
We can only conclude that perhaps the little positions that have been given to some of them that were very vocal in these issues have tended to be issues of bread and butter that they don't wish to abandon at this particular point. But I think rights of individuals must be respected. Let individuals express themselves. I keep saying this. Democracy is a marketplace of ideas. You can disagree with me, but I must be able, or you must be able to protect my right to hold the opinion that you do not agree with.
Yeah.
I must be able to express my opinion without fear, because that is guaranteed by the Constitution. So the mere fact that I think that the position that you hold is not a correct position, notwithstanding that your position, if held by so many people, can lead to a crisis, doesn't matter.
Yeah.
It doesn't matter. If someone is going to say, okay, look at what is happening in other countries. Maybe our country would be better if what is happening in another country would happen here. That is my opinion. That is an opinion that I hold. You may not disagree with it. It may be suggestive of an illegality, but I hold the view. You must be able to protect my right to say what I say. Because if I'm going to keep it in my head, that is not what we structured our Constitution to be. We did not structure it so that people keep their thoughts to themselves. They must be able to express those thoughts. As a matter of fact, the very things that people are talking about, things to do with tribalism, things to do with violence that is being perpetuated, tribal remarks that are being made, you will see that these are issues that people discuss on the tables in their kitchens.
Yeah.
When they bring it out, you say you shouldn't be talking about that. It is true that the extent of tribalism that is being exercised or experienced is much more rampant than ever before.
Yeah.
It is true that the people that are being favored are seemingly coming from a particular region. It is very true, and people are able to justify that. They look at the promotions that are being made. They look at those that have been laid aside and stopped from working. We have over 430 civil servants that have been surrendered to cabinet, that are staying at home, doing nothing, getting paid. And if you look at the regions that they come from, you'll be able to say that, okay, there seems to be an issue that is going against these people that are coming from this region. Yeah. Those sentiments used to be made previously. Those sentiments are being made now, especially now they are at a much more large scale, because the experience, everyone is experiencing it and saying it should not be so. It should not be so. And the people that are talking about that are talking about in the sense of condemning it, that it should not be the norm. They're not talking about it in the sense of that it should be promoted. If they were saying it in the sense that it should be promoted, therein lies an offense. Yeah. If they are talking about it in the sense of condemning it, then you should protect their right to say it, because they're saying this illegality should be stopped, and they're not saying this thing should be perpetuated. But instead you are having people that are saying, no, let him come here and we're going to circumcise him. Those people are not being punished. Yeah. And those people are saying, no, you can't do that. You should not be doing what you're saying should be done. Are saying, okay, because you said that, you are suggesting that people should be violent. What you said is capable of making people rise and be violent. No. It's not about the capacity to make people rise and be violent. The person that you should be punishing is the person who rises and becomes violent. Because the person who says or condemns a particular act says this is wrong and should not be done. Yeah. Yes. Yeah. But we seem to be having problems.
No. Clearly, there is that threat of freedom of expression, freedom of movement, and you just can't believe that we are in a democracy. And I believe all those reports saying there is a dictatorship under reign currently. Honorable Makebi Zulu, you stopped me from calling you Honorable Makebi Zulu. Mr. Makebi Zulu.
Yes, sir.
I think it's been an interesting journey. I hope to bring you just to speak to specific issues. I brought you generally to, I think, for the country to know who you are, who Makebi Zulu is, what forms Makebi Zulu, and why does he comment about the issues he comments about. I'm glad that you took the particular cases of the 3 judges and the issue of the eligibility case to demonstrate that you just can't reopen cases in the manner they are reopening. And you just can't abandon your previous ruling of your office because you are the new office holder, What are your last words?
Well, perhaps my last word is that this is our country. My last words, as it were. This is our country. We need to protect it. It is incumbent upon each and every one of us to protect the democracy that we have. Respect for the rule of law, that must be paramount. And this government must switch to that particular position. Because it appears as though now the modus operandi is, let's clamp down on the opposition. Let's choose who our opponents are going to be in the next election. That should not be the case. Every citizen should arise and protect the democracy of this country. They should arise and ensure that the opposition is able to speak and speak freely as regards matters. They should allow the public to be able to weigh the opinions of different political parties for purposes of making a formidable decision as to who they want to lead them. You can't be the one to want to choose what the people are going to hear, what the people are going to say. We had an interesting issue where you go to a private property called the Cathedral of the Child Jesus and say, you can't gather here. You stop the Archbishop from going to gather there. What gives you the power? What gives you the nerve to stop someone from getting onto their own property without justifiable cause, without a court order? The invasion on people's privacy has been exponential in this regime.
The former president wanted to go and lay raids yesterday, and they sealed the area.
They sealed the area. There's been this utter abuse of the police, which should not be the case. We have degenerated into a police state. Hakainde Hichilema used to say, Zambia has become a police state. It's 10 times much more under his watch. And it can only be that because he chose to be in charge of all law enforcement agencies, he's the one that's calling the shots. It's time for him to wise up and protect this country, not just for himself, for his children and children's children, his great-grandchildren, and for his legacy as well. He shouldn't go down in history as a person who brought the democratic credentials of this country to its knees. Currently, democracy of this nation, the rule of law, is on its knees. And it is not President Hakainde Hichilema who will lift it up, because he has shown in the 3.5 years that he's been there that he has failed, and failed lamentably. He should wise up and do the right thing.
That between honey and the banana, you think that the banana is sweeter than honey.
He thinks a banana is sweeter than honey. You can never convince him that honey is sweeter than a banana.
And if you put a bag of money here and the banana, he thinks that the banana is better. He doesn't know that the money can buy more bananas. Makebi Zulu, constitutional lawyer, renowned Lusaka lawyer. You've seen him take up those big cases in our country, and he's been a regular commentator on public, civic, and legal issues in our country. I was privileged to host him to discuss the state of democracy and human rights in Zambia. It's a matter of serious worry, and it's been documented by various international reports. In the past, Honorable Makebi Zulu, I'm disappointed. In the past, it will be our own civil society groupings that will demonstrate that the rule of law is under threat, that democracy is threatened, that will highlight these human rights issues before international reports caught on. But now it's the opposite. It's like all our civil society and human rights commission are literally silent or intimidated or reactive, whatever it is. We are now allowing international bodies to determine and decide about who we are, instead of our own institutions highlighting. But I guess that's what dictatorship does. It cows everyone into silence. Dear viewers, until we have another guest next time, God bless you, God bless our country, and shalom, shalom.